tell me, do you believe that Mr. Andrade knew about the hearing today?
Yes, sir, he did. We both kind of discussed it, and he said that he had been served. Somebody had came to his house, and he was fully aware of it. And I did receive a voicemail yesterday reminding me of today's appointment as well, too.
And did he give any indication to you as to why he wouldn't appear or if he was going to appear?
No, sir.
And so you're asking for the court to move forward on a default order today without him being present. Is that correct?
Please.
And moving on, so the child in this matter's name is Bryson Lee Stokes. Is that also true?
Yes, sir.
And how old is Bryson?
He just turned 2.
And when Bryson was born, or at minimum conceived, you were married to somebody other than Mr. Ryan Adrande. Is that correct?
Correct.
And you are presently divorced from that person. Can you tell me that person's name?
Kyle Wellman.
And during the divorce process, there was DNA that was ordered to rule out Mr. Wellman. Is that also true?
Yes, sir, that is true.
And if I may share screen, Your Honor.
Yes, sir.
Miss Stokes, on the screen, there should be what is listed as a DNA paternity report, and this the alleged father in this action for this DNA testing report was Kyle Tyler Wellman. Is this the document that ruled out Mr. Wellman as the father?
Correct.
And so when that was presented to the court in the divorce proceeding, then the court went forward with a divorce. And I'm going to share that.
I'll take judicial notice of the screen shared DNA report showing Mr. Kyle Tyler Wellman had 0 probability of paternity for the child Bryson. And I assume it's in the divorce decree as well, which you're now sharing.
That's correct, Your Honor. And if we scroll down to the part where it says child of the marriage, the court found that there was no child of the marriage between that was
Okay.
the child of the petitioner and the respondent in that divorce.
Okay, and for the record, you screen shared the page of the agreed final divorce decree between Miss Lauren Wellman and Kyle Wellman. And it does have that statement you just put on the record. So I'll take judicial notice of that. We don't need to have them admitted or attached to the order, any of those, that kind of stuff. Correct, Mr. Colano?
That's correct, Your Honor.
So just notice for the record. Okay.
Thank you. Miss Stokes, so you believe that Ryan John Andrade is the father of the child, Bryson Lee Stokes, correct?
Yes, he was there during his birth, and he has not once said that he is not the father. He's aware, and he knows, and as I do too.
Okay, and so Mr. Andrade has held himself out as the father.
Yes, he knows. Yes.
He calls himself the father of Bryson.
Yes, sir.
He's attended birthdays of Bryson.
Yes, sir.
And he's told his family that he's the father of Bryson.
Yes, sir. We've met a lot of his family. He's very well aware that he is a father, and he knows that. And
okay, and you didn't have intercourse with any other person around the conception time that could possibly be Bryson's father.
no, sir.
And so you're asking the court to find that Ryan John Andrade is the father of Bryson Lee Stokes, correct?
Yes, sir.
And you're asking the court to name you joint managing conservators and you as the primary conservator.
Yes, sir.
You are asking for a visitation schedule that is modified and somewhat limited. What you're asking the court to order is the third Sunday of every month from 12 to 2, supervised at your residence for 9 periods of possession, and with a 24 hours notice of that visitation if Mr. Andrade is going to take it. Is that correct?
Yes, sir.
And why is it that you're asking for such a minimalized visitation for this order?
Because I doubt that he will even attend any of it. He has made it very clear that if we're not in a relationship, me and him, then he doesn't want to move forward.
Has Mr. Andrade ever changed Bryson's diapers?
Once or twice, but that's about it.
Has he fed him?
Once or twice.
Has Bryson ever stayed overnight at Mr. Andrade's house?
We have, but I stayed with him. He's never stayed by himself.
Has Mr. Andrade ever spent any time over, let's say, an hour with Bryson without you being present?
No, sir.
So you've always been present when Mr. Andrade has been around Bryson.
Yes, sir.
When was the last time Mr. Andrade saw Bryson?
His second birthday. I had invited him over to come over to my house for his birthday.
So a little over a month ago, probably.
Yes, sir.
And before that, how long had it been?
I honestly can't. I'm not sure. It was a while.
More than a month?
Yeah.
So you're asking for once a month for 9 periods is kind of what's been happening anyway.
Correct. And of course, if he wants to see him more, that's perfectly fine. I'm not trying to keep him from him. I want him to be a part of Bryson's life. It's just, I feel like he doesn't want to. If we're not in a relationship, he gets upset and he pulls back.
Okay. And so you understand that the court order will have a paragraph that says that if the parents come to an agreement that you can do whatever you want with visitation and you're more than willing to let him see the child.
Yes, sir. If he wants to see him more, he is more than welcome to come over to my house and he
Okay. And after these 9 periods of possession, then you're willing to go to the first and third Sunday of each month from 12 to 4, but you would still like it to be at your house with you supervising. Is that true?
Yes, sir, please.
And you would like to do that until there's some other court order that says vegetation should be something different. Is that what you're asking?
Yes, sir, please.
So at this time in the child's age, you don't feel comfortable that Mr. Andrade has had enough time with the child that you would feel comfortable with going to like an overnight possession schedule.
Correct.
Okay. You're not afraid of Mr. Andrade in any way. He hasn't harmed you.
No, sir.
So you're not asking for a non-disclosure. You're perfectly okay with having the visitations at your house.
Yes, sir.
As far as the child support is concerned, do you know what Mr. Andrade does for a living?
The last that I was told, he does some, honestly, I can't, something about, it's like a smart shift on his phone where he can pick up hours, at a Circle K where he can work for a certain amount of time.
So it's kind of like a fill-in.
Yes, sir. Yes, sir. He has
Okay.
before at other locations, at like Tesla and Amazon, working lines and putting things together. But as far as I know, it was the Circle K.
Okay. The default in the state of Texas when we don't have information on somebody's income is we default to minimum wage, just presuming that they can at least get a minimum wage job. Are you okay with child support, with the court ordering child support based off of minimum wage?
Yes, sir.
And in the calculations for minimum wage, that would be a gross income of $1,256 a month. And can you tell me how your child is covered by health insurance?
Through the state, through Medicaid, and in June, starting in July, he'll be getting CHIP.
Okay. And so the state will be asking for a medical support reimbursement of $57, which is half of the 9%, which is the maximum allowed by law, 9% of the gross for reimbursement for medical. And that would make the net income, which is what we figure child support off of, $1,160 per month. And you're not aware of Mr. Andrade having any other children, is that correct?
No, he does not.
And so if we use 20% of the net, it comes up to child support of $221 per month. Is that what you're asking the court to order?
Yes, sir.
And you understand that will begin on July 1st, 2025?
Yes, sir.
The state will be asking for $57 for cash medical support reimbursement, and that will also begin on July 1st, 2025. And you're also asking for retroactive support. Is that true?
Yes, sir.
Has Mr. Andrade ever provided you any kind of support for the child?
He may have bought some milk and some diapers, maybe $200 worth.
And you're willing to give him $200 worth of credit against the retroactive support?
Yes, sir. Yes.
And you never lived together with Mr. Andrade and the child?
No, sir.
And so if we go back to the date of the birth of the child, which in this case would be the maximum allowed by law, I calculated that 26 months could be would be the amount that we could ask for retroactive support on. And if we use $221, that would equal $5,746. And giving him credit for 200, that would be $5,546. But you're willing to just drop it down to $5,000, round it down. Why are you willing to do that?
Just because I'm being nice. I'm not trying to go after him. I just want him to do his part, and I'm okay with dropping it down.
And you're asking for the minimum reimbursement on that at $75, which is the interest plus $50, or about 70. The interest plus 75 plus $50 is about $75, and that's what you're asking the court to impose. Is that correct?
Yes, sir. Please.
And you understand that would also begin on July 1st, 2025?
Yes, sir.
And so is there anything that we have not discussed that you'd like to tell the court about your situation?
No, sir. I mean, I've tried. I'm the one that has always been putting Bryson on his dad. He has never once denied him. He doesn't have a vehicle, so I'm the one that always has to like go to him. And I've tried and tried. Yeah, I mean, it's not that I have ever kept him from him.
Okay. No further questions for Ms. Stokes, Your Honor?
Okay, is there anything you weren't asked that you feel like you need to put on the record or let me know about, Ms. Stokes?
No, ma'am.
Is Stokes your main name?
My maiden name, yes, ma'am.
And I think I heard earlier that the child carries that name as well.
Yes, ma'am.
You're not asking to change it to Andrade.
No, ma'am.
Okay. And you heard the part about visitation. You can do, it does say you can do whatever you want by agreement, but failing agreement, this is what he's stuck with. So technically he would be stuck with supervised visits till the age of 18, but I have found that somebody changes, either the child wants to see the dad or the other parent, or the parent changes and grows up and gets a little wiser and realizes they need to get involved. But you can do anything you like. I've seen all sorts of things, including weekend visits without a court order if you agree to it, or dinners every so often, once a month or something like that. But keep that in mind, because if things change, if you don't have a court order and you don't have the money to hire a lawyer to race in a court, if you all agree to something different, please do it if you think it's in your good judgment, good for the child, and you don't think he's going to kidnap the child in any way. So, but you have a court order that gives you custody, so you could still have remedies. So understanding all that, Ms. Stokes, that's what you want the visitation order to be, fairly limited and indefinite.
Yes, ma'am.
Okay. On the rest of it, I don't see any problems with it. Oh, and pick up and drop off, it's going to be at her house, correct? Is that what I'm?
That's correct, Your Honor. There is going to be a 24-hour notice provision as well.
He's not on drugs or alcohol or anything, use or abuse that would concern you that I'd need to put in the order that shouldn't happen anyway, but.
No, ma'am, not that I'm aware of.
Okay, great. Then Mr. Calvano, do you need to do a closing or do I need to repeat everything?
No, no closing necessary, other than I didn't mention any court costs in this
Yeah.
case we don't ask that Mr. Andrade be the person ordered to pay those costs. And I would like to point out that I believe Ms. Stokes, if I may just ask one more quick question. Part of the reason for not wanting overnights right now or to move on to overnights, can you just tell me quickly where not where, but whom Mr. Andrade lives with and what his living situation is?
Yes, sir. He lives with his brother and a roommate in a 1-bedroom apartment, and Mr. Andrade sleeps on the sofa. His brother sleeps on the floor. He doesn't have a car seat. He doesn't have a car. The living situation just is.
Okay, and so I'm just asking you those questions to reassure the judge as to why you're not asking for the visitation schedule to move to overnights.
Correct. Thank you.
Okay.
So much. I appreciate that.
No further questions, Your Honor.
Hey, I don't know why people don't come to court because he could be arguing here. If he were here, I would hear more, but he's not here, you're here, and I'm gonna grant all your requests. I'm not gonna repeat any of it because I have a lot of people waiting to get into the courtroom for the 1030 cases. So I'm gonna just tell you, Ms. Stokes, I'm gonna approve the order. The state's gonna draft it. I'm rendering the order by default against Mr. Andrade. It's my order now, so you can walk away. You can't change your mind, or if you change your mind, I'm still gonna sign this order. And you are telling me that these orders are in the best interest of your child?
Yes, ma'am.
Okay, so the last part of the process is the AG drafts it, sends it to you by email. Check your emails for anything coming from the Texas Office of the Attorney General. Consider it priority homework. Hopefully no later than 5 at the latest. So we do have a full day today. However, start looking after 5 at the latest. If you sign it, review it in the next day or two, that'd be great. I get it quicker if, but I give it 1 week. So by next Tuesday, if you haven't signed it by Monday or the state hadn't heard back from you why you haven't signed it, then they'll submit it to me without your signature. Since it is my order, I can sign it without you, but I'd much rather you review it first if you can. Okay?
Yes, ma'am. Thank you so much
Okay.
for everything.
If you have no questions,
I do have one question. I don't know how this works. This is all new payment. How does that get, how does that all that?
the state can talk to you about that. I don't have time to explain it. However, it's ordered, and if he's working, they take it out of a paycheck, and if they doesn't, well, you talk to them about what you need to do. Okay?
Thank you so much. Have a wonderful day.
Thank you, ma'am. Back to you and your child, and all you have to do is click the end meeting buttons so you can be removed from the courtroom. Thank you.
Ms. Stokes, I can put you back into a breakout room and explain that if you want.
Please, sir.
Okay. And that's allowed, then I'll go ahead and stop my recordings at this time. I'm gonna start the live stream first.